Chancellor Patton, President Gertler, Dean Brunet, distinguished members of the Platform Party, family and friends of the graduates, and most importantly, the graduates, the class of 23. Good afternoon. Or maybe it's still morning. Good morning. Thank you for including me in this wonderful day of celebration. It is such a privilege for me to be here, and I wish to thank everybody who was involved in selecting me for this special honor. I'm particularly thrilled because the law faculty is my alma mater, and my memories of the time that I spent here are really good ones. June is one of the best months of the year for showcasing the diversity that's Canada because of its focus on Indigenous peoples. It is the National Indigenous History Month, time to recognize and celebrate the cultures and spiritual beliefs of First Nations, Inuit, and Métis people in Canada. And because in June, we also celebrate other diverse and vibrant communities who contribute so much to our country. It is Italian, Portuguese, and Filipino Heritage Month and Pride Month. So we've got a huge mix of people to celebrate in the month of June. The incredible diversity of our country is one of the things I love about it. Over time, I think it breeds tolerance because we're not insulated in separate communities. Most of us from many different backgrounds with many different languages and cultures are rubbing shoulders with each other daily in our schools, our workplaces, and neighborhoods. It's hard to hate people when they're your colleagues, classmates, and friends. For me and for many others, my time at U of T was formative. We were part of the boomer generation growing up in the aftermath of the Second World War, and we wanted to make the world better. It was the 1970s, the women's movement, the anti-war and anti-nuclear protests were huge. And at the law school at U of T, we were very active. We pressed for course credit for working in student legal aid clinics, and I believe you still get credit for volunteering to work at student legal aid clinics. We participated in the artistic woodworkers strike, which was a lengthy and rough strike for a first contract for the workers at that place. Carloads of us went out to picket lines in the early morning, and Dean Friedland had to step in with character references to help a few students who faced charges for protesting on the picket line. It's amazing at times what we learned at law school, because I had never been in a picket before I came to law school. The workers got their first contract, but it was at a great cost, and we learned a lot from that process. We prepared a detailed brief to contribute to the reform of Canada's immigration laws in 1975 when the government was considering new legislation, and I think our brief was the best of all the ones presented because we all participated in it. It was from working in student legal aid that I came to know of the problems faced by immigrants and refugees. Among our first cases were refugees from Chile and Argentina. They were university students protesting in the streets of their cities, just as we'd been in our cities, only they were detained, tortured, and killed. We weren't. So it was, for me, a real lesson. Several of us learned Spanish, and when we became lawyers, we kept practicing immigration and refugee law. My classmates and first law partners, Nancy Goodman and Brent Neeson, are up on this stage today with me. And we all speak Spanish. We continued in this work for a while. Brent became a judge, Nancy became a board member. But during those years, we had little money, but we loved our work. We were fortunate to be involved in several legal challenges over the years seeking to advance human rights protections for non-citizens, and more recently for Canadians as well, Canadians detained in horrific conditions abroad. I learned valuable lessons over the last 4 decades. I'm just going to address 2 of them, which I think may be of relevance for you going forward. The first is affecting change. I learned from my first time in the Supreme Court of Canada that winning a case isn't winning the battle. In Singh, a 1985 Supreme Court judgment, the court recognized that non-citizens could claim the human rights set out in the Charter. They decided that fairness required that refugees be given an oral hearing to determine the merits of their need for Canada's protection. We won. We thought we won the point that human rights for immigrants were entrenched in the Charter. The legislation was changed to provide for an oral hearing, but we still continued to lose well-founded refugee cases. This was because the issues are so much more complex. A single remedy may help, but it doesn't resolve the problems. With the Singh case, it was not just the hearing process that needed fixing, it was the appointment process. Some of the decision makers were political appointments and some were just awful. Looking at the oral hearing as an opportunity to try to trip up claimants and reject their claims. So we had to address those kinds of problems as well. And then the definition of refugee itself is narrow, an issue that's going to increase in importance over the years as Canada begins to receive climate refugees, people who have nowhere to go because their land isn't there anymore. They weren't contemplated when the convention was drafted after World War II to protect refugees. The hope of broader human rights protections for immigrants held out by the Singh judgment hasn't happened. The right to resist removal to a country where a person would be persecuted or subjected to cruel treatment has been recognized, but not other important rights, such as protection of the family unit, not separating parents from their children. We're 40 years later arguing some of the same arguments that we made in the Singh case, whether non-citizens can truly claim protection under the Charter. What happened after the Singh judgment was issued isn't unusual. It's happened with other cases. The Supreme Court issues a judgment. The lower courts, at least in immigration law, tend to be cautious about applying it, so it gets distorted, and it creates new issues to be litigated. The other case I was going to talk about was Kanthasamy, but I'm worried about running out of time. I'll do it really quickly. In Kanthasamy, the Supreme Court in 2015, because it's a good example, again, of how things don't change. The Supreme Court decided that humanitarian and compassionate grounds to let immigrants stay in the country it was just that. The officer had to decide, are there humanitarian and compassionate grounds, not anything else. They were deciding if it was unusual, undeserved, or disproportionate to make the person leave Canada. And the court said that wasn't the test that was to be applied because that wasn't what was in the statute. So we won, it goes back to the lower courts, and now they're applying a test of exceptionality where they say if it's exceptional, then there's humanitarian and compassionate grounds. It may end up back in the Supreme Court. We've been there twice already. So it just shows that you have to keep at these things. New issues arise. It doesn't always get you where you want to go, but you can't stop. What it does show is that change is slow, it's not linear, and it's not unbroken. And it's a continuing process. It doesn't start or stop with a single case. Rather, it's advocating to maintain the rights we have and to attempt to advance them further. The second point that I wanted to make is the importance of maintaining our democratic form of government. I've represented people from all over the world, from governments that are not democratic, from governments that purport to be democratic but aren't. Democracy is a really important institution, and we are so lucky in Canada to have it. When I was in Chile in the 1980s, I've talked about this before, but for me it was really impactful. In the 1980s, I was in Chile. I attended, it was under the Pinochet dictatorship. I attended a Santiago Bar Association meeting where one of the lawyers from the Catholic Church's Human Rights Office spoke about habeas corpus. Habeas corpus in the Chilean system is the same as ours. It's a fundamental, foundational human rights remedy that's been there forever. He had reviewed the case law around the time of the military coup in '73 and realized that habeas had been thrown out, that habeas was a toothless remedy. Any excuse the police gave was sufficient for a judge to dismiss the writ without requiring that they bring the body to the court. What was shocking about that was that the judges weren't from the military. They weren't military appointments. They were ordinary judges, Chilean judges who'd been appointed before the coup by a democratic government, who became lawyers under democratic government. Chile had had elections since 1932. The demise of habeas, more than the military might, showed just how fragile Chile's democracy had been. The safeguards put in place to protect against abuse didn't work. Of course, there was resistance to the military, but the rapid collapse of other branches of government highlighted the frailty of democracy. It can be gone in a day. Democracy is fragile. It depends on the goodwill and willingness of our community to make it work. When I started practice, we were looking to build a better world. In the decades after World War II, there was a belief that we could not repeat the war. We had to establish democratic and fair forms of government. You're in a different time, a very different time. I think you face a world where there is growing assault on democracies, including ours. It's not a time to be complacent, but to ensure that you don't take for granted the right to vote and the right to participate in society. I think strengthening democracies should be part of our lives, all the more so as lawyers, diplomats, civil servants, academics, teachers, whatever you choose to be. You can become involved more directly in so many ways in your jobs and beyond them through church and community activities, supporting human rights, environmental, and other social movements. And you know, if you don't have time, and I know early years being a lawyer are really time-consuming in terms of work, donate. Sign petitions that you support and donate, at least in some way, participate. And at a very human level, you can speak up where you see discrimination and other forms of unfair treatment in your workplace, government offices, and in the courts. It's not always easy, especially raising problems like that before a judge. You may not be well liked by some because of it, but we won't improve without it. I would love to come back 10 years from now and see where you're all at and how you're doing. My contact with students has been ongoing over the years, not like I was teaching all the time or anything, but we've had students around the practice for many, many years. And I have to say, I've really been impressed with students of your generation. I hold out a lot of hope that you'll improve on many of the problems that we're leaving you with. Good luck in whatever you choose to do, and I really hope you enjoy it. Thank you.